So there's a firm who is suing the IRS. Yep, that's right. You heard it right. They are suing the IRS, claiming that the IRS is causing them economic damage as a result of the moratorium they put in place related to the ERC filings. So this is a fascinating lawsuit because it really gets to the frustration that a lot of folks are feeling that they filed for the ERC and they've been put in limbo and they're validly claiming this money, and yet the IRS is not giving them any response whatsoever. So I wanted to share a couple of the highlights from this court case that I'm watching very closely. I think it's fascinating, not just as it relates to the ERC, but around some of the legal precedences that have been issued by the Supreme Court recently. So I'm gonna go ahead and share my screen because I'd like to do that, show you the source documents so you can follow along with me. So this lawsuit, Stenson versus the United States Internal Revenue Service. So first of all, it takes some courage to file a lawsuit against the US government and the IRS. Kudos to them. So Stenson is a tax advisory firm. They've done a lot of work in the ERC and they've multiple clients, and they're suing the IRS, saying that the IRS has damaged them. They're causing financial harm to the firm due to the moratorium that been put in place. And they're suing them to tell the IRS to get court action, to tell the IRS to lift the moratorium and start processing these claims. And so if you're following along with these videos, follow along in the news recently, you know, IRS has issued a lot of press releases, some of them very valid, but also some of them very sensational, talking about the massive fraud that perpetuated in the ERC system. While there's certainly fraud, we personally feel that sometimes the IRS is leaning a little heavily on saying that everything is fraud. So when you look at this court case, this is really interesting because this gets to what's actually being said kind of behind closed doors, but on the record. So the first thing I thought that was really interesting is that the defendant IRS claimed to have processed about 3.6 million valid ERC claims, with about 1.4 million remaining. So that 1.4 million number, that's not, we know that, you know, the number of claims that have been stuck in moratorium for September of last year. But the interesting thing is the use of the word valid. So this is the first time that I've personally seen the IRS admit these claims they've processed are indeed valid. So I thought that was very interesting. It was a pleasant relief to see the IRS admit, yes, we've processed a lot of these claims, but most of them are indeed valid, as opposed to some of the press releases that indicate the opposite. The second thing I thought that was really interesting is there's, of that 1.4 million backlog claims that are stuck in moratorium, the estimated government interest on this obligation is over $4.2 billion. That's a lot of money. And I wonder if the firm that is suing them is using this as leverage to say, listen, Mike, we understand that you want to ensure the sanctity and functionality and reliability of the tax system, as we all do, and has the pendulum perhaps swung a bit too much the opposite direction, where now it's costing billions of dollars due to the IRS's very slow processing of these claims. So that's really interesting. Now, the thing I find the most interesting, and there's been a little bit of chat within the industry about this, but of note that as a federal administrative agency, the IRS is no longer entitled to deference in interpreting the statute. So remember, this language right here, this is the judge's opinion on the case. So the reason he's writing an opinion is because the plaintiff, the company suing the IRS, was asking for an immediate injunction to force the IRS into lifting the moratorium. And so of note, they talk about the rules around ERC. So specifically section 3134 of the tax code and a portion of the CARES Act that instructs the IRS commissioner to issue this credit. So Congress creates the rules and the IRS, as a function of the executive branch, the IRS administers the rules, but Congress creates the rules. Specifically, the IRS went to put into place these notices and guidances and rules around the ERC. They were interpreting what Congress wrote. Recently, there was a U.S. Supreme Court case called Chevron. Well, actually, Chevron is from decades ago, from 1984, but recently there was a court case that overturned the Chevron principle. The Chevron principle is that the administrative state has the latitude and the leeway to interpret what Congress says and make their own rules as a result around it. Well, this court case just invalidated Chevron, stating that, well, no, the administrative agencies, you can't defer to their judgment interpreting these statutes. They need to rely on the written word of Congress as it relates to the interpretation of any ambiguous language in the act. So a lot of legal scholars are saying that Chevron is limiting the ability of administrative agencies to come up with their own new and novel definitions for things that they may not be entitled to do so. I thought it was really interesting. In this opinion, the judge mentioned the Chevron case that the IRS is no longer entitled to deference in interpretation of the CARES Act. So we're going to continue to follow this case. I'm going to continue to issue updates on it and highlight things that I think are interesting. And I hope this video is helpful. And if you have any questions at all, please reach out.